car repossession in South Africa. The process for repossession of a vehicle is very complex. You need to be careful if a debt collector or representative from the bank comes to you requesting for you to sign forms that allow them to take possession of the vehicle. This is not a legal process, and should you sign, you will consent to the voluntary surrender of the vehicle, which you do not have to agree to. Vehicle repossession can only take place via an official and original court order named a warrant of execution. You would also firstly have had to have been served with a legal document called a summons, which gives you a chance to defend yourself. These documents would have been delivered to you by a sheriff of the court. The legal process of car repossession in South Africa. 1. According to the National Credit Act, any creditor can send you a Section 129 letter of demand if your account is in arrears for 20 days or more. 2. Creditors are allowed to proceed with the legal process of the collection after one missed payment. 3. The process that needs to be followed when a vehicle is repossessed is in terms of the Section 123 letter of demand. The notice basically gives you three options. You must bring your payments up to date, or engage a debt counselor, or if you've stopped paying due to a dispute with your creditor, refer the matter to an alternative dispute resolution agent, consumer court, or an ombud with jurisdiction. You have only 10 days from the date of delivery to act on the notice. If you fail to do so, your creditor may hand over your account to a debt collector, which will result in you paying debt collection fees on top of everything else that you owe. Or your creditor may apply to the courts for a default judgment against you, which will be noted on your credit report for 5 years and have a negative impact on your chances of obtaining more credit or getting credit at a good rate. Your credit provider must be able to prove that a Section 129 notice was delivered to you. This is in terms of a 2012 landmark judgment handed down by the Constitutional Court, which states that the purpose of the notice is to give you a last chance before court enforcement procedures drop the guillotine on you. Before this judgment, it was enough for a credit provider to show it had sent a notice to your address. But since the judgment, if you never received the notice, you can contest legal action on the basis that the notice didn't reach you and you were therefore unaware of your rights. A Section 129 notice must also be dated and refer to the agreement in which you are in default and the default amount.